If you saw headlines screaming about a Supreme Court 6-3 emergency ruling that changes everything and impacts millions, you need to understand what's actually happening. Because these headlines are technically true, but they're also deeply misleading. The Supreme Court has issued multiple 6-3 emergency rulings in 2025 and 2026. And yes, millions of people are affected. But here's what those headlines don't tell you. These aren't final decisions. They're temporary rulings on what happens while cases are being litigated. They're issued on the shadow docket with little explanation. And they follow a troubling pattern that reveals how the court is reshaping presidential power in real time. Are you subscribed? Because what I'm about to explain is how the Supreme Court's emergency docket works and why gun owners need to understand this system even if these specific cases don't involve guns. Hit subscribe now because 90% of people see these headlines and have no idea what shadow docket actually means. Let me start with what the shadow docket is. The Supreme Court has two dockets, the merits docket and the emergency docket. The merits docket is what most people think of when they imagine the Supreme Court. Cases take months. There's extensive briefing. There's oral argument. Justices write lengthy opinions explaining their reasoning. Decisions are signed. You know exactly who voted which way and why. The emergency docket is completely different. Also called the shadow docket or the interim docket. Cases move in days or weeks, not months. Briefing is limited. There's usually no oral argument. Decisions are often unsigned. Sometimes there's no explanation at all, just an order saying request granted or request denied. When there is an explanation, it's usually a few paragraphs, not dozens of pages. The court doesn't hold hearings, the public doesn't get to watch, and the decision happens fast. Now, emergency relief has always existed. The shadow docket isn't new. Circuit justices have always had the power to grant stays or injunctions in urgent situations, death penalty cases, elections, situations where waiting for the normal process would make the case moot. But what's new is the volume and the stakes. Here are the numbers. From 2001 to 2016, covering the Bush and Obama administrations, the federal government filed a total of 8 emergency applications, asking the Supreme Court to stay lower court rulings. 8 applications in 16 years. During Trump's first term from 2017 to 2020, the Department of Justice filed 41 emergency applications. That's a 5-fold increase. During the Biden administration, from 2021 to 2024, the number dropped, about 19 applications over 4 years. But then Trump returned to office in January 2025, and the numbers exploded. From January 20th, 2025 to late 2025, the Trump administration filed at least 30 emergency applications. Some trackers count even more, depending on methodology. That's more in less than a year than Biden filed in 4 years. And here's the key stat. The Supreme Court granted relief in approximately 20 to 24 of those 30 applications. The administration is winning about 80% of the time on the emergency docket. And most of those wins are 6-3 decisions. 6 Republican-appointed justices in the majority, 3 Democratic-appointed justices dissenting. The same lineup almost every time. If you're finding this helpful, imagine what you'll learn in my next video where I explain how shadow docket decisions could affect future gun rights cases. Subscribe now. Let me give you examples of major 6-3 emergency rulings from 2025. First, birthright citizenship. In his first week back in office, President Trump signed an executive order declaring that children born in the United States to undocumented immigrants or temporary visa holders are not automatically citizens. Multiple federal judges issued nationwide injunctions blocking the order. They said it violates the plain text of the 14th Amendment. 3 courts of appeals refused to stay those injunctions. The Trump administration went to the Supreme Court. In June 2025, in a case called Trump versus Casa, the Supreme Court ruled 6-3 that nationwide injunctions are not valid. The court allowed the executive order to take effect except as applied to specific named plaintiffs. The 3 liberal justices dissented. The court did not rule on whether the executive order is constitutional, it just said the injunction was too broad. The merits case is still pending. Second, FTC commissioner removal. In March 2025, President Trump fired Rebecca Kelly Slaughter, a Democratic member of the Federal Trade Commission. Slaughter argued her removal violated for cause protections for independent agency members. A federal district court agreed and ordered her reinstated. The Trump administration filed an emergency application. In September 2025, in Trump versus Slaughter, the Supreme Court stayed the district court order, 6-3. Slaughter's firing stood while the case was appealed. The court agreed to hear the case on the merits, and oral arguments happened in January 2026. But for months, the emergency stay allowed Trump to keep Slaughter removed. Third, immigration enforcement. Multiple cases involving Trump's immigration policies have reached the shadow docket. Temporary protected status terminations. Expedited removals. Use of the Alien Enemies Act. In almost every case, lower courts issued injunctions. In almost every case, the Supreme Court stayed those injunctions. 6-3, allowing the policies to proceed. Hey, 73% of people watching aren't subscribed. Don't miss critical Supreme Court updates. Click subscribe now. Now, let me explain why this matters and why it's controversial. The shadow docket is supposed to be for emergencies. True emergencies where waiting would cause irreparable harm. The classic example is a death penalty case. If an execution is scheduled for tomorrow and there's a constitutional question, the court needs to act fast. That's a legitimate emergency. But critics argue that most of the administration's applications are not real emergencies. They're policy disagreements where the administration wants its preferred policy to take effect immediately instead of waiting for the normal litigation process. Justice Elena Kagan has been particularly vocal about this. In her dissent in Trump versus Slaughter, she wrote, quote, "This court should not be used to transfer government authority from Congress to the president, and thus to reshape the nation's separation of powers." She's arguing that the court is using the emergency docket to make major constitutional changes without the deliberation and transparency of the merits docket. Justice Ketanji Brown Jackson has also dissented repeatedly. In one immigration case, she wrote, quote, "This court has once again paved the way for the immediate infliction of injury without adequate or really any justification." Not only does the court's stay determination produce inequity, but it is also part of a broader pattern of this court using its emergency docket to cavalierly pick the winners and losers in cases that are still pending in the lower courts. Justice Sonia Sotomayor joined both of those dissents, and she's written her own strong opinions. In a case about immigration stops in Los Angeles, she warned, quote, "We should not have to live in a country where the government can seize anyone who appears to match a certain profile, speaks Spanish, and appears to work a low-wage job. Rather than stand idly by while our constitutional freedoms are lost, I dissent." These are extraordinary statements from Supreme Court justices. They're accusing the majority of abusing the emergency docket, of making decisions without proper analysis, of consistently favoring one party, of operating in secret. And here's what makes it even more troubling. The decisions are often unexplained. The court grants the stay. It issues a one-paragraph order. It doesn't tell you why. It doesn't explain the legal reasoning. It just says, "Application granted." Sometimes there's a brief explanation, maybe 2 or 3 paragraphs, but nothing like the detailed analysis you'd get in a merits opinion. And because the decisions are unsigned, you don't always know which justices voted which way. You can infer from dissents. If 3 justices dissent, you know it was 6-3. But you don't get individual explanations from the majority. This lack of transparency is a huge problem. Quick legal note, this is educational information only, not legal advice. Shadow docket decisions are complex and fact-specific. Consult an attorney for legal questions. Now, let me explain what this means for you. Even if you don't care about immigration or independent agencies, you should care about the shadow docket, because the system the court is creating affects all constitutional rights, including gun rights. Here's how. The shadow docket decisions are setting precedents. Even though they're supposed to be temporary, they're changing the law. For example, the nationwide injunction ruling in Trump versus Casa. That's a major change in federal courts' equitable powers. Lower courts used to be able to issue nationwide injunctions blocking unconstitutional policies. Now the Supreme Court has signaled that's not allowed. That affects every future case, including gun rights cases. Let me give you a hypothetical. Let's say a future administration issues a rule banning commonly owned firearms. Gun rights groups sue in federal court. A judge agrees the ban violates the Second Amendment and issues a nationwide injunction. Under the pre-CASA framework, that injunction would protect people across the country. Under the post-CASA framework, the administration could argue the injunction is too broad. The Supreme Court might stay it. The ban could take effect everywhere except for the named plaintiffs. Millions of people would be subject to the ban while the case is litigated. That could take years. The shadow docket ruling would have effectively weakened protections for the duration of the litigation. Second example, the removal power cases like Trump versus Slaughter. If the court ultimately rules that the president can fire independent agency members at will, that affects agencies like the ATF. The ATF director currently serves a fixed term and can only be removed for cause. If that protection goes away, future presidents could fire agency leaders based on policy preferences. The independence of the agency disappears. Third example, the speed and lack of transparency of shadow docket decisions means people might not even know their rights are at stake until it's too late. Imagine the government issues a new rule. You challenge it. The case moves to the shadow docket. A decision comes down in a week. Unsigned, unexplained, your rights are gone. You didn't get a hearing. You didn't get to file an amicus brief. The public didn't get to watch oral arguments. It just happened. That's the concern with the shadow docket. It's not about left or right. It's about process. It's about transparency. It's about whether major constitutional questions should be decided quickly and quietly or slowly and openly. Now, let me address the 6-3 pattern. Why is it always the same lineup? Because the 6 justices in the majority and the 3 in dissent have fundamentally different views about executive power, federal courts authority, and the role of the shadow docket. The majority believes in strong executive power. They're skeptical of lower court injunctions against the executive branch. They think the shadow docket is an appropriate tool for managing those injunctions. And they trust that if a policy is truly unconstitutional, the merits litigation will eventually address it. The dissenting justices believe in aggressive judicial review of executive action. They think lower court injunctions are a critical check on presidential overreach. They think the shadow docket is being overused. And they worry that temporary harm can become permanent if policies take effect for years before the merits case is decided. These are deep philosophical disagreements, and they're playing out in real time on the shadow docket. Here's what you need to understand. Shadow docket decisions are supposed to be about irreparable harm. The standard is whether denying emergency relief would cause harm that can't be fixed later. For death penalty cases, that's obvious. If the execution happens, you can't undo it. But for policy cases, the analysis is murkier. The government argues it's harmed if it can't implement its policy. The challengers argue they're harmed if the policy takes effect. The court is supposed to balance those harms. But critics argue the court is systematically favoring the government's claimed harm over individuals' harm. Justice Jackson made this point in one of her dissents. She said the court privileges the assertion of executive power over individuals' pleas for stability. In other words, the government says we need this policy now, and the court agrees, even without rigorous analysis of whether that's true. Meanwhile, individuals saying this policy will harm them are told to wait for the merits case, which could take years, by which time the harm is done. That's the critique. It's not just coming from the dissenting justices. A survey of 65 sitting federal judges found that 47 disagreed that the Supreme Court had made appropriate use of the shadow docket since the second Trump term began. Only 12 judges said the shadow docket had been used appropriately. That's striking. Federal judges, who are typically deferential to the Supreme Court, are publicly criticizing the court's emergency docket practices. That almost never happens. All right, let me bring this back to what it means for gun owners. First, the shadow docket could be used against gun rights in the future. If a future administration wants to implement policy quickly, it could use the same approach. Issue the rule. Get sued. Lose in district court. Appeal and file an emergency application. Get the Supreme Court to stay the injunction. Implement the policy while the case is litigated. By the time the merits case is decided, millions of people have already complied. The rule has been in effect for years. Even if the court eventually strikes it down, the impact has already occurred. Second, the erosion of nationwide injunctions is a major issue for rights-based litigation. Groups often file cases in favorable jurisdictions and seek nationwide relief. That strategy just got much harder. Third, the lack of transparency means you need to watch the shadow docket closely. These decisions happen fast. If you're not paying attention, you'll miss them. And by the time you hear about it, the decision is already made. Fourth, the pattern of 6-3 decisions gives insight into how the court may rule in future cases. The same majority is likely to approach similar legal questions in consistent ways. Your action steps. First, start following shadow docket trackers. SCOTUS blog has an emergency docket page. The Brennan Center tracks shadow docket cases. These resources will keep you informed. Second, understand that emergency rulings are not final. When you see a headline about a 6-3 emergency ruling, remember it's temporary. The merits case is still pending. The real decision comes later. Third, support transparency efforts. Some members of Congress have proposed shadow docket reform. These proposals would require the court to provide more explanation for emergency decisions, more time for briefing, more transparency about who voted which way. Fourth, recognize that this affects all constitutional rights, not just gun rights. If you care about one right, you should also care about due process, separation of powers, and judicial transparency. Let me give you the bottom line. The Supreme Court has issued multiple 6-3 emergency rulings in 2025 and 2026. These rulings are reshaping presidential power, limiting lower courts' ability to check executive action, and setting precedents that will affect future cases. The dissenting justices have repeatedly warned that the court is overusing the shadow docket, and the pattern is clear. The same lineup ruling the same way in case after case. This is not a left versus right issue. It's a process issue. It's about whether major constitutional decisions should be made quickly and quietly or slowly and openly. If this video helped you understand what shadow docket actually means and why these 6-3 emergency rulings matter, do two things. First, subscribe. Second, share this video. Every American needs to understand how the shadow docket works and why it's controversial. Legal disclaimer. This is for educational purposes only. It does not constitute legal advice. Shadow docket decisions change rapidly. Always consult a licensed attorney. Stay informed, stay engaged. See you in the next one.